Hello, everyone, and welcome to ECI's webcast overview and implications of the DOJ's new enforcement policies. My name is Pat Harned. I'm the CEO of the Ethics and Compliance Initiative. It's my great pleasure to welcome you here today. And I have the distinct pleasure of welcoming our two speakers who are joining me today for this conversation. Let me just take a moment and tell you their full bios are on the platform, or links to their bios, because it would take, we have 45 minutes for this and it would take a long time to just, speak to all of their great accomplishments. But first, we're joined by Andrew Weissmann, who is professor of practice with the Center on the Administration of Criminal Law at NYU. Among Andrew's accomplishments, he was lead prosecutor for Robert Mueller's special counsel's office. He served as chief of the fraud section at the DOJ, also was general counsel for the FBI and served on deputy, then was director of the Enron task force, along with Lisa Monaco, who served on that task force, just to point that out. Andrew also has been an assistant U.S. attorney. He served in private practice. And I'm really pleased to share that he is also a member of the ECI Board of Directors, a new member to our board. He also, for those of you who are MSNBC watchers, you know that he's a regular contributor there. We're also joined by Daniel Kahn, who is a partner of white collar defense and investigations at Davis Polk. Some of you joined me for previous conversations about what we expected to hear from the DOJ with respect to the Monaco Memo, and Dan was my partner in crime, so to speak, and speaking about those things. Dan joined his firm in September of 21, having been serving at the DOJ for 11 years, where he served in a number of different roles. Among them, he was acting deputy assistant attorney general of the criminal division. He too was chief of the fraud section. Prior to that, he headed the FCPA unit under one Andrew Weissmann. So the two of them served together at the DOJ. And I was saying before we came on that while the two of them were in their roles at the DOJ, that's when a number of great advancements happened from our perspective as an industry in terms of the DOJ's providing more information about how they evaluate ethics and compliance programs. So thank you both, Andrew and Dan, for being here. Welcome to the webcast. So our task today is, of course, based, pretty simple. Last week, it's widely known now that the Deputy Attorney General delivered a speech and released a memorandum where she spoke to the DOJ's priorities, new policies on enforcement, corporate enforcement. So I just want to start off with just one quick question, and that is that, as I have read the commentary and heard a number of pundits talk about this new memorandum and the new policies, I've heard people refer to it as sweeping changes to the DOJ's enforcement practices. So Dan, I just want to start with you. What is your take on that? Are these sweeping changes?
Yeah, thanks so much, Pat, and obviously a pleasure to be here and to share a stage with both of you. Obviously, a very esteemed group, minus me, I suppose. But I guess in terms of what the changes are, I actually don't think they're sweeping. And don't get me wrong, I think that there is a lot that was announced, and there's a lot to unpack. But at the end of the day, I think the main takeaway is there is still a considerable amount of discretion that is left to the prosecutors. There weren't really a lot of hard and fast rules, and the hard and fast rules that I think were announced were much more in line with the speech that she gave back in October of 2021. And I think that they're in a very good way. I think there was a lot more nuance to some of the points. I think with respect to recidivism, for example, with respect to monitors, and I think that's very helpful and is really a step forward from last year. But at the end of the day, I do think that we're going to have to wait and see how prosecutors carry this out. I think, frankly, the biggest development from all this is, again, the continued emboldening of prosecutors to really be a little bit tougher on corporations, and hold them to a higher standard for cooperation and otherwise.
So Andrew, just a follow-up question to that. What's your overall impression of the policies that the DAG put forward in her memo? Any surprises to you?
So I agree with Dan that this is much more about continuity than any dramatic change. And my initial take was that in many ways, this showed internal growth in terms of how they think about corporate criminality. This isn't a department where you would say there's an enormous amount of depth in sort of thinking about corporate crime in the way that there maybe in other administrations or people who were just steeped in that world. So I saw this as growth on their part, and I think that's actually very useful in terms of when you're in trouble or if you're a compliance officer or general counsel, knowing that the department is sort of advanced in their thinking. I too, though, think that there was a lot left for resolution down the road. As when we were preparing for this, Dan said, well, this is a sort of interesting thing because a year ago we were told there'd be a working group, and then when you read this memo, there's a lot of, well, we're going to have more policies to come. Well, this was the question of sort of what happened during the year. So we'll talk about sort of things that are still unresolved, and that I guess that's where I was a little bit surprised that there wasn't a crystallization of certain issues and certain long-term issues that the department's been wrestling with that I thought might get at least addressed in this memo, or started to be addressed, and they weren't.
And one of the things the three of us were talking about as we were preparing for this is that, in a way, the good news of that is that it opens the way for further input to the DOJ from communities like ours in areas where this current memorandum is unclear, or those areas where the DAG has tasked the departments with developing further policies. So it's not all bad that they weren't quite as thorough as we thought they might be. So
absolutely.
One quick housekeeping note, because I should have said this at the top. For those of you, we welcome your questions. At the bottom of your screen, there are two buttons. There's one button for chat. There's another button for questions. If you would kindly put your questions into that section that says questions, and we're happy to answer anything that's on your minds. And also, frankly, in the chat, if you have suggestions of things, areas for clarity where you want for us as an industry to be trying to speak further with DOJ, we welcome your input about that as well. So to move on to my next question, as both of you have said, last October, the Deputy Attorney General gave a speech and issued a memorandum that was essentially preliminary, outlining some priorities in terms of enforcement against corporate crime. And she laid out, we all talked about at great length, essentially three primary areas that she wanted her corporate crime advisory group to further explore and advise her on any policy needs. So I want to just take a couple of minutes and do a lightning round, if you will, to talk about those three areas. And most of you, I suspect, on this call are familiar with them. The discussion around individual accountability for past misconduct, recidivism, and also there was a great deal of discussion previously about the use of independent compliance monitorships. So we'll do a quick lightning round around that. And actually, I'm going to take the first one, which has to do with individual accountability. And I'll also say on this platform, you can find the Monaco Memo if you have not yet downloaded it. It's available for you to be taking a look at. So first and foremost, the DAG was iterating in her memorandum that the first priority of the DOJ is to hold individuals who commit and profit from crime accountable for their wrongdoing. And as our group was talking yesterday, we said the rest of it is essentially, see also the Yates memo from September 2015. And Dan Andrew, chime in if I am saying something that's incorrect, but the rest of the discussion was further speaking to what was essentially laid out by Sally Yates in her previous memo when she was DAG. But what DAG Monaco spoke to was the fact that to be eligible for cooperation credit, companies have to disclose all relevant non-privileged facts and evidence about any individuals involved in misconduct. I think the big emphasis here was on timely disclosure. The DOJ wants companies to come forward swiftly because of the expiration of statutes of limitations, the dissipation of corroborating evidence, things that have clearly gotten in the way of their prosecution in the past. And so to that end, the DOJ also further talked about the importance of providing communications amongst any individuals that are associated with misconduct. And then they addressed any prosecution that's happening in foreign jurisdictions, and recognizing that the DOJ has the ability to decline to prosecute depending upon the strength of the other jurisdiction's interests, their effectiveness in prosecution, the likelihood of consequences. But for the most part, when it seemed to me, and Dan and Andrew, any thoughts here, but it was really see the Yates memo. We support what Sally Yates put forward before. Any other additional thoughts on that?
No, I mean, I totally agree. I would just emphasize the timeliness point, which, the one comment that gave me a little concern was when the DAG said that defense counsel's first call when they discover a hot document during the investigation should be to the prosecutor, which I think hopefully will not be interpreted literally, because the penalty for the company is the denial of cooperation credit or a huge reduction. And as you all know, certainly better than anyone, practically speaking, as a matter of fiduciary duty, as a matter of just how this works, the first call can't possibly be to the DOJ. And if you just send them documents without actually trying to understand the context of those documents, you may actually be leading the DOJ down a rabbit hole. So that's the only additional point I would make there.
So the second area, to keep us moving forward, and Andrew, I'm going to defer to you on this one, is a topic that we know the DAG got a great deal of feedback about when she raised it last October. Lots of people had thoughts, and it had to do with accountability for past misconduct, recidivism, when companies have repeated problems for which they are appearing before DOJ. So thoughts on how that turned out in the memo that the DAG released?
Yeah, so the good news is the evolution in a good way of the department's thinking about recidivism when you're talking about a company as opposed to an individual. I think the DAG in her speech said this was the area by far where she got the most input, which I think probably meant criticism. And I think the reason for that is, as I'm sure everyone here knows, companies are not like individuals when it comes to recidivism. We're not talking about one person. And when I was in the department with the Dan, we used to tell our junior prosecutors who would sometimes get on their high horse, we would say, you know who else is a recidivist? The Department of Justice. Because in any large organization, there will be players who do something that's against the rules. And the larger the organization and the longer that they've been extant, it's almost a certainty that that's going to happen. So there was a real evolution in thinking, and there was guidance given that a lot of it is common sense, that prosecutors were told to look at first maybe was the conduct in the United States. Did it involve the same players? Did it involve the same type of misconduct? One area I thought was a little ambiguous is they said, did it involve the same root cause? That's a little concerning because root cause taken to an extreme, everything could be the root cause is that there was an inadequate compliance program. So that's not the most helpful, and that's where I could see that being interpreted in the field in ways that's not helpful. There is some guidance given about time, so that if there is a dated criminal resolution of over 10 years, it will carry less weight than something that is more recent. And for a civil case, it's 5 years. So there's a variety of guidance. The part which is maybe not as good news is the idea of if there is a finding of sort of recidivist conduct, that certain things are sort of presumptively taken off the table. So that if you've had a NDA or DPA in the past, it is going to now require real supervisor approval and more scrutiny if that's going to happen again. That strikes me as a wrong presumption. There just seems like there's so many situations where that wouldn't necessarily be warranted. Now, having said all that, this memo leaves room for the right result to be achieved, but I'm not sure it signals, again, to the field exactly how to do this. And that of course, is always the issue, is not how do you deal with the department when you've got a very sophisticated player. Is there somebody who's not that sophisticated who's going to look at this memo and say, see, you've had an MPA before, so you're not getting it again.
So the third area, and we're happy to come back and answer any questions about these three priority areas. The third area, Dan, was another one where we know there was a great deal of input from our community, from all different kinds of stakeholder groups, and that had to do with the use of independent compliance monitorship. So highlights things that you saw in this memorandum related to that.
Yeah, and I think, like with recidivism, as Andrew was talking about, this is an area that received a lot of criticism, frankly, following the October 2021 speech, because in October 21, the DAG said that she was going to be rescinding a policy that disfavored monitors. Now, there wasn't a policy that disfavored monitors, and so I think everyone's presumption from that speech was that the DAG was signaling that there was going to be more monitors. And I think I think to the department's credit, to the DAG's credit, I think they listened to all of the input from ECI and other stakeholders. And I think this was a very reasoned piece of guidance with respect to what came out last Thursday. So it was essentially that there's not going to be a presumption against monitors, but there's also not going to be a presumption in favor of monitors. And they did come out with additional guidance on the selection criteria. A lot of that guidance looks very similar to the guidance that the criminal division of DOJ put out in 2018, but it expounded on that. And I think there were about 4 factors in the 2018 guidance. There's 10 in this one, and a lot of them are along the same themes, which is, what does the compliance program look like at the time of the misconduct? Does the underlying conduct relate to the controls or a control breakdown? And what types of resources is the company putting into the compliance program? So I think it struck the right tone in terms of how a company can avoid monitors. And then the other point that I think was helpful was, and again, I think this is a reaction to some of the feedback from ECI and other organizations, was the recognition that monitors can be very, very intrusive, and can often and very easily have a problem of mission creep, and really go beyond what their mandate is, or claim that the mandate is much broader than it is. And so the DAG talked about monitoring the monitors, and that they wouldn't just put in place a monitor and let them do whatever they do. And I think this is something that under Andrew's leadership, the fraud section started doing a few years ago, of really having regular meetings with the monitors and the companies, training the monitors making sure that everyone is on the same page as to what the monitor should be doing, and making sure that they're not going off and for lack of a better term, going rogue. And I think it's a positive development that this is going to be department wide.
I learned a new word from this whole discussion, that the DOJ led equipoise when it comes to use of monitors. I had to look it up. It's a great word. It's a good Scrabble word. But Dan, you referenced ECI's offering input. To their credit, DOJ held a series of roundtable discussions, listening sessions. I remember the two of you being involved in previous efforts like that when you were putting together the FCPA guidance and other documents. And we were invited to attend. At the time, it was clear that DOJ, with respect to this topic in particular, had a great deal of interest in hearing from compliance officers who had had experience with monitors. And some of their concern came out in what the DAG spoke to, because of the discussion about the prosecutor remaining involved with both the company and the monitor, being concerned for scope creep and billing, and is this monitor adhering to the plan that was put forward in the beginning. So I do think that's progress. We'll see how it comes out in the end. But so another big topic of that I know people are interested in has to do with voluntary self-disclosure and cooperation by companies. And this ties back to, Andrew, a lot of what you were talking about with respect to recidivism. So the DAG dedicated a section to this topic, and the emphasis wasn't exactly new, but what were the changes that you noticed in the DAG's memo?
Well, I think, Pat, the first thing to start off with is continuity. I will talk about some of the changes, but in general, the theme here is I won't say business as usual, but all of the concerns and all of the things that you would flag as outside counsel, as compliance officers, in-house counsel, for what voluntary self-disclosure is and what are the benefits and risks remain the same. It really is, there's very little that is different. I think there's what I would call embroidery or tinkering around the edges that obviously are important. So let's just turn to that. As we've talked about, one of the things has to do with speed. And Dan correctly flagged that potential issue, but that was also always there, that you can't just drag your feet. And if you were seen to be doing that, that was going to be, and as Dan knows, certainly from his time at the department, that was something that was factored in if you had belated cooperation. But there is that emphasis. In addition, there were certain factors that are new and were sort of go into the determination of whether there is voluntary self-disclosure. So I know we're going to talk about issues about, in addition to speed, about what kinds of things, if you want to say that you have fully disclosed and have an adequate compliance program at the time, and have remediated, the government's going to be looking at some factors that may have played a role in the past, but are now really sort of flagged in this memo. So for instance, did the company have a system to make sure that people who participated or had oversight responsibilities in connection with a fraud, that there's some sort of financial disincentive to them? That is something that I know Dan certainly focused on when he was running the FCPA unit, when he was head of the fraud section, and it's definitely flagged in prior agreements. But this really puts it to the forefront, saying that that's something that if you're going to come to the department and say, I'm a good corporate citizen, they're going to be looking at what kind of structures are in place for that kind of clawback. In other words, is there a financial incentive to make sure there's sort of good compliance? There's an emphasis on having compliance, certainly having a seat at the table. That has been said over and over again, but again, it takes real prominence in this memo as a ground. And then a third area, which I actually find fascinating is this whole idea of whether there should be a mechanism to make sure that the company can see all messaging and has access to emails and texts. And there's sort of an interesting history in the Department of Justice. When Dan and I were in the department, we actually had that as part of the policy, but it was not terribly vocal because I'm not sure we would have gotten a lot of support from above on that issue. It then disappeared for a while as something that the department shouldn't be looking to. And now I think it's really taken a prominent place. And that is basically dealing with an issue that we've obviously seen in the press in other contexts involving, let's say, the Secret Service. But this issue of, is there going to be data that the company has that's available? And so all of that's going to be in the mix of a company coming forward and saying, I want voluntary self-disclosure credit as a good corporate citizen. In other words, that it's not enough that I just came forward, but you need to then say, yes, I reported and I'm a good corporate citizen. So I think those are sort of key things. And obviously we've talked about recidivism, which is that you could do all of this, but if you're tagged as a recidivist, you're going to have an uphill battle. And maybe just to make final word on that, which is personally, I think that is probably going to be counterproductive if you are a player like a large financial institution where you are by definition going to have problems in your past in the same way as I mentioned the Department of Justice does. This does create a real disincentive to be reporting and trying to obtain voluntary self-disclosure credit. Yeah,
and just to pile on, to use another DOJ term, the sticks. I totally agree with Andrew. The sticks are tougher to get cooperation credit, more likely to lead to a guilty plea if you're a recidivist, which are most multinational corporations, and all of the other heightened requirements that Andrew was talking about. The carrot that the DAG announced was that the voluntary disclosure across the department, at least, I think the FCPA corporate enforcement policy is going to remain the same, but other components, the default is a presumption against a guilty plea absent aggravating circumstances. So in other words, by disclosing and taking on all those additional risks, what the baseline is that you're not likely to get a guilty plea absent aggravating circumstances. Now, of course, in the past, at least, you normally wouldn't be facing the prospect of a guilty plea unless there were aggravating circumstances. So again, I think that the carrot stick balance was way more in favor of this stick.
Dan, do you want to just maybe just so that people understand, talk about what the default is in the FCPA program, just so they see that what people see what that difference is?
Yeah, and without getting into sort of internal deliberations, I will say, when Andrew was the head of the section and we put out the FCPA corporate enforcement policy, the decision, the ultimate result was to push for and have a presumption for a declination, meaning that the department would walk away so long as the company fully cooperated, fully remediated, disclosed, and paid back essentially forfeited the corrupt proceeds. And so the thinking, of course, is that in order to get companies to voluntarily disclose, you need to make the carrot big enough to counterbalance all of the other collateral consequences that we haven't even talked about, which is SEC resolutions, class action lawsuits, foreign investigations, and even if none of those things happen, a years-long investigation, which can be extraordinarily disruptive to the business.
So to switch topics a little bit, one of the things that was clear in the DAG's memo was the importance of effective compliance programs. And this, of course, I think has been the evolution of a lot of thinking by DOJ over the years. And to be honest, I credit the two of you for having been in the department when the first evaluation questions were released, when Wei Chen was there. Andrew, I know you were instrumental in bringing her into the department. And over the last few years, we've, of course, seen the criminal division put out the evaluation criteria guidance. This memorandum, I think, my sense is it's intended to further reinforce that effective compliance programs make a difference to the DOJ when it comes to consideration about prosecution. My question for the two of you is, what did you see in this guidance in terms of any new thinking about the DOJ's criteria? Is there anything new that they're adding to the list?
Dan, I'm going to refer.
Sure. So I think Andrew hit most of the big ones, which is the personal devices messaging apps and the financial clawbacks or financial incentives, both positive and negative for compensation. I think I guess a couple additional points to note. One is the third, I would say in the trifecta, the third is non-disparagement language in contracts or agreements, employment agreements, severance agreements, that essentially a company is not stifling whistleblowers. And that's not going to be anything new to publicly traded companies that have to comply with SEC regulations. And so an easy solution there is just to ensure that you have some caveat in any non-disparagement clause that makes clear that it doesn't refer to disclosure to regulators about potential misconduct. But I think one important point to note, and this goes back to something that Andrew said at the beginning, which is none of these are hard and fast rules at this point. The DAG essentially announced that the DOJ criminal division, which is where the fraud section sits, will be coming out with new guidance on these issues. They're going to be studying them and coming out with new guidance for the department. One other point to just note, because I think it is important, and Andrew emphasized this, I think rightly so, which is the personal devices and messaging apps. That is something that I think companies struggle with. And I think it's something that, frankly, the DOJ struggles with because it's not at all clear how to deal with that issue. Do you prohibit the use of it, in which case you force individuals underground and they're using their devices in a way that's not captured by anything? Do you allow it and put things like WhatsApp on work devices? Do you have some other type of system that tries to capture it? Do you simply require employees to make sure that they retain those messages, take snapshots in a way that is consistent with the retention policies overall? So I think that is a really sticky wicket in general. And you see the issues that have come out with the SEC with financial institutions and the sweep they're doing there. But DOJ, I think, continues to try to understand how to address that issue and how to incentivize it and how to penalize it, because I think really everyone is struggling with that issue.
So we have a number of great questions that have come in, and I want to make sure we allow time for those. I do have one last question for the two of you before we move to audience questions. And that is, where were there missed opportunities or places where the memorandum was silent that we thought the DOJ might say more? I'll throw out the first one, which is on the minds of a lot of folks in our community. Requirement of CCO certifications at the end of a monitorship. So many speeches, lots of discussion about it. Kenneth Polite was out speaking about that, and yet this memorandum was quiet about it. Any comments about that, but other areas that you saw that were either missed opportunities or places where it was silent?
Let me just quickly flag three things. One is that the memo is interesting in saying that they want other components in the department to be coming up essentially with their own FCPA program. As Dan noted, there's sort of minimal requirements, but that could be a positive in terms of input, but it also could be fraught because there are a lot of people who don't deal with corporate cases. And so it's great that they're thinking about essentially doing this nationwide. But there was a trying to leave the field to come up with their own policies, but I think with sort of minimal guidance. So that is an area that I think everyone has to keep their eye out for, and there's an opportunity for input. A second area is that this memo didn't say anything about the civil division, and you could do all of this on the criminal side, and it's not clear that how it's going to work with the civil division. I was a little surprised that they didn't take over a year to really tackle that issue. Now, to be fair, that has not been tackled in any other administration either. And then the third is there wasn't an effort to try and figure out how this jives with the antitrust division policy. And frankly, in a couple places, there's some obvious discrepancies. The antitrust division doesn't, at least de facto, have a policy of how to treat a recidivist company. I mean, they may say they do, but frankly, if you're the first in the door, you still get complete immunity, and you get complete immunity not just for the company, but for the individuals. Again, that is a de facto policy. And so that is a perennial issue that has not been dealt with by an AG or DAG, but this memo continues that tradition of not tackling that issue.
At least not yet. So let's move to the audience questions. The first one is, has there been any consideration of the impact of public declinations and declinations with disgorgement on companies' willingness to voluntarily disclose wrongdoing? Has DOJ tracked the rate of disclosures pre and post CEP?
So, and so I don't think that the department has released any data on that. I will just tell you, just from my experience and anecdotally, I think that the disclosures have increased. I think the department cares less about the quantity of disclosures and much more about the quality of disclosures. And I think, over my time at DOJ, there are oftentimes voluntary disclosures where it's, $1,000 payment to a customs official that DOJ wouldn't bring, whether it was a voluntary disclosure or not. Those are not the types of cases that the DOJ is trying to incentivize. And I think after the pilot program and then the corporate enforcement policy, you do see, and you start to see them in the publicly announced declarations, that there are companies that are disclosing real misconduct, where there are senior executives who are alleged to have been involved in the misconduct. And I think that is what the DOJ, the FCPA unit, the fraud section, is aiming for. And I think you see a lot more of that now than you have in the past.
So the next question is that the AAG, Ken Polite, the head of the criminal division, has been emphasizing program testing in his recent remarks. What are your views on this topic specifically, with as much granularity as possible? What does DOJ want to see? Is this area likely to be clarified further by DOJ in the near future?
So what I would do on that is, the department has put out a lot of questions and guidance. And I think the easiest way there is to read all of that in terms of the kinds of questions that the department itself uses when a company might get in trouble. That was the whole impetus for it and genesis for this starting many years ago. And that is actually an area where I think it has gotten more and more granular. And so I think that is something that a chief compliance officer with the general counsel, and ideally senior management, they go over to figure out how would they answer each and every one of those questions. And there's a real emphasis also on continuity. In other words, that it's not enough to just do it once, that you're supposed to be sort of continually looking to see, is it working? So I think, there's so many aspects to this that it's hard to, I know the question asks for granularity, but it's really hard because there's just so many different things that the department asks, which is understandable. And so I think that would be my general advice on that.
So I want to ask a question that I know both of you have probably spent a great deal of time thinking about when you were in the department regarding foreign cases. What are DOJ's parameters for determining they won't go ahead and prosecute? Oh, authors of the FCP. I know both of you, this is your sweet spot.
Yeah, look, I think, and I think the DAG outlined some of those factors, but they're probably common sense factors, which are, where are the equities? Is the individual a foreign national who lives abroad? Was the conduct of that individual largely abroad, or was it in the United States? Is the foreign authority who's prosecuting someone that the DOJ trusts as a partner? If you look at what the system over there looks like, the justice system, does it look like the DOJ feels as though that person is going to face a similar or appropriate punishment if they're convicted? So I think those are the types of things that the DOJ looks at, and you do see certainly, this happened while Andrew was there, while I was there, a significant increase in the level of cooperation, to the point where it's not just some sort of formal, hey, we'll get along to work on this case together. I mean, there really are relationships between the DOJ and a lot of these foreign countries, and the SEC as well. And so these are very fluid conversations that are happening, throughout the investigation.
And the one thing that when we were the department, the one thing I'd caution is, well, I agree with everything Dan said, is I think there's a real concern on the part of the department if they sense any gamesmanship, where there is U.S. jurisdiction, but the company, and it's clear that there would be U.S. jurisdiction. We're not talking about something that was sort of unforeseen or unknowable. And the company tries to essentially resolve something overseas without and claiming sort of good corporate citizenship in one country without flagging it for the United States. And then when the United States finds out about it, saying, oh, but we dealt with it. I mean, that I think that kind of thing can get you in much more trouble. And as Dan said, the fact that there's an overseas investigation or resolution is something that is more and more going to be hard to do without the United States knowing, because there's such global cooperation.
So another question is a topic that I know we spoke to a little bit. Can you comment more on clawback and messaging apps provisions? These are areas chief compliance officers will need to consider how to action responses. Definitely an area that has not really been discussed too much in our field yet, but will be now.
Yeah,
maybe I'll do clawback.
Yeah,
sorry, go ahead.
Yeah, no.
I'll do clawback, and you want to do PDAs, and so with clawbacks, maybe historically, I can give you an example of that. When this is public information, when there was a resolution with JP Morgan Chase in an FCPA matter, one of the things that they talked to the department about was various clawbacks of compensation, including for people who just had supervisor responsibility. And that, I think, led to certainly within the fraud section, us thinking more about that and the importance of it. And I think that is what you're seeing, sort of the growth of that being very important to the department, and trying to systematize it so that it's not just something that happens as a one-off after a problem has occurred, but there's actually it is communicated to the workforce that this is a consequence, and there's criteria, and there's an implementation of that. And I think that, to my mind, is a very salutary aspect of what Lisa Monaco announced. And I think if you are a general counsel or a chief compliance officer, putting that in place is going to be, you now know that if you want to get this sort of credit from the department, that is what will be needed. And the thing, again, if you're looking for guidance, if you go to the various resolutions that are public and noted on the fraud section website, you will see instances of where that has occurred, and that at least gives you a starting place to see how a program can work.
Yeah, and the only thing I would add is agree with all of that. The only thing I would add to that is I've spoken with a couple of clients who operate in jurisdictions where this may be more difficult, and I think what DOJ is really trying to get at here is just some sort of financial penalty to individuals who, as they put it, contributed to the misconduct. So I think Andrew gave a good example of a supervisor who themselves weren't necessarily involved in the misconduct, but nevertheless it happened on their watch. And so whether it's clawing back a bonus or whether it's cutting a bonus in the future, if the jurisdiction you're in doesn't allow you to claw back, but Andrew's absolutely right that to the extent you can build this into employment contracts or policies, to have that in place, that is something that DOJ will be looking at. And then on personal devices and messaging apps, again, I mean, I think it's so case specific. It depends on whether a lot of companies don't have work issued devices, and so everyone is using a personal device. And so what policies are you going to put in place around that and around the use of messaging apps? I think a lot of companies are considering switching to ephemeral messaging as a primary basis for for communications, not in some nefarious way, but as a document management tool, and facing the other problem where you're worried about hacks because everyone keeps all of their data for years and years and years. And you're trying to make sure that you're able to run an efficient organization. So again, I think it's case specific, and sorry to give a hedge answer, but certainly always happy to talk about specifics offline.
Well, and clearly these are topics that we'll be continuing to talk about in the days ahead. And of course, we'll keep an eye on what's happening within the department, particularly because we know different sections are now needing to think about how to enact and move forward with these policies. And with that, I'm sad to say that we've hit the top of our time. Andrew and Dan, thank you so much for being here. It's always a privilege for us to hear from folks who know from the inside and also just from your experience having come from DOJ. Thank you for being here today. Before we completely sign off, I want to just point out to folks that this afternoon, it's a double header, if you will, from ECI. We have a best practice forum scheduled for today at 2 p.m. We encourage you and invite you to register. It's not too late. The topic is maximizing the impact of your training program, which we know is something that is always very difficult to do. So please, we welcome your registering. We also shout out to NAVEX for their sponsorship of that event. And with that, again, thank you everyone for being here today. Thank you again, Andrew and Dan, and we will see you at the next DCI event. Have a good day.